on the 3, section 3B of the ODS Act, only on the 3, section 3B of the ODS Act, unless there is reasonable belief that
there was an order passed on 6/3/2025, and you took time also on 27/3/2025 that you want to produce those documents as per the order dated 6/3/2025.
Well, I have applied the
Learning Council for the petitioner.
That has not received.
Time to
That's the last year also I have mentioned below.
Documents as per the order dated so on so put up after some more petition. Yes, next.
Item 2.
Better Miller, let the State Council take the instruction and
Yes,
record.
it is your case.
Your petition you have to substantiate.
Yes.
The application said that the record is not received.
Item number 2.
Item 2.
May be pardoned to appear through VC milots. Milots, I am on VC milots. May I be pardoned to appear through VC milots?
You are supposed to file an
This
affidavit.
morning, Milos, this morning we have filed 2 affidavits in both the cases, Milos. As per last order, we have complied it, Milos. May be posted next week, Milos. We can place them.
You submit that affidavits, 2 affidavits which were supposed to be filed. As per the order dated 23/4/2025. Which was supposed to be filed has already been filed. Already been filed today.
This morning, Milos.
Let the affidavits be placed on records. Copy of the affidavit be furnished to the Learning Council for the state out of this matter after some of the petition.
Item 3.
Item number 3,
Compliance affidavit.
if yesterday another matter, all the matters have been posted to 8th of this month. But in that order, a wrong number has been reflected that
8/5/2025 as prayed for by the Lion State Council. Yes, sir.
Item 4.
Order dated 23/4/2024 minus 3 days not complied. Last week you will not send directed.
Yes.
An order has been complied with. Item number 4 now.
Pass on that compliance order.
A application has been rejected.
You have got an extra copy too. Pass on copy again. State company or central Mishra state company. As a petitioner has also been intimated about it.
Intimation এটা করছিল
এটা তো intimation দেওয়া আমাদের। আচ্ছা। দেখুন, the land council for the state has produced the written instruction received from the special LA and ROR from our lower Indra irrigation project Korea dated 17 to 2025 to indicate that the order of this court dated 23/4/2024 is passed in WPC number 9548 of 2024 has been complied with, and the order has also been communicated to the petitioner. The order is taken on record and the contempt proceeding is adopted. Yes.
Item 5.
Some time maybe.
The land council for the state seeks some more time to obtain instruction regarding the status of representation filed by the petitioner before the contender of the opposition party number 3 to top up for summer vacation.
Item 6.
My lord, matter, I am appearing for the opposite part number 4. Your lordship will see this matter has been arranged as a reference, which is annexed at annexure 1. The opposite party number 3 can say about the status of the, it is not been paid. The amount has been deposited with the competent authority. Thereafter, they have made a reference under annexure 1.
The order dated 28/1/25.
My lord.
Read that order. 28/1/25.
My lord. National Council, I'm just reading the direction, the last part of the Landed Council of the National Highway Authority shall obtain instruction as to whether any money has been deposited in Office Partner 2 and Land Acquisition Officer, Company of National Highway Authorities of Odisha, and as per the order passed in the by the. My lord, this, if your lordship will see that annexure 1, your lordship, it is then reference under section 3H4, your lordship, the enforcement of the awarded amount. The enforcement of for the because there is two party involved. If your lordship is as
But instruction is been received by the National Highways Authority.
The Kala can tell that the competent authority can because they have referred the matter for the to the under section 3H4. If your lordship is read page 12 of the writ petition.
Who is appearing for National Highways?
I am appearing for National Highway Authority.
Yeah.
My lord.
Who is the petitioner counsel?
My lord.
What do you say?
Till date, I have not heard any amount. Apportionment has been made as per annexure 1.
Just a minute. As per the order dated 12/24 passed by the district of Ganjam, in which reference under sections 1 so made by the Tahsildar was answered, and it was disposed of with a direction to the competent authorities to disburse the value of the land to the deity, to the inspector, and the value structure to the respondent number 2 within a period of 2 months from the date of receipt of the land council will submit that in spite of such order being passed since more than 3.5 years, the petitioner is yet to receive the Mr. Mahanti for appearing for National Summons, the petitioner was not included National Highways Authority party wish to make the payment. Section and payment of payment of national health shall obtain instruction whether any money has been deposited with the opposite party number 2 land acquisition officer so on. When Jam as per order passed by the district judge, if so, the disbursement money, then you file that interim application because married as in a party. Then shall obtain instruction. Also, the order dated sponsor. Yes, what is your submission?
My lord,
Have you deposited the money?
it's the kala because the direction has been given to the competent authority to disburse the amount, which is because there's a dispute regarding the apportionment of the land.
Whatever you want to say which authority is having
Opposite
the
part number 3, your lord.
file an affidavit. File an affidavit.
My lord, opposite part number 3,
Put up this-
competent authority.
Put up this,
File an
file an affidavit that before whom you have deposited. The Land Council for the National Highways Authority shall file an affidavit by tomorrow, indicating before whom the money which was supposed to be paid to the petitioner has been deposited. Put up this matter day after tomorrow.
My lord, in fact, we have writing the letter to the competent authority. They are not
File
giving
the
reply.
affidavit by day
That
after.
is,
Anyway, you have deposited, na? You have deposited.
We have
If-
deposited.
Yes,
That's it.
if you have deposited, give, file an affidavit and give the date of your deposit before whom you have deposited. Tomorrow, the affidavit to be filed will take up this matter day after tomorrow.
My lord,
Otherwise, it will be sent to the jail. Yes, next.
Item 7.
The order typed as so and so shall be read as so and so. Yes.
Item 7.
Item 7, Lord. The last having also directed to produce certified copy of the order sheet. Just submitting.
Yes, where is the order sheet?
PO was on. One signal.
Item 8.
Yes, sir.
See, you are telling, you made a submission on the other day that on all the dates you are taking steps. The submission we have recorded on 25 to 2025. That is why we asked you to file the order sheet. Your submission was that after filing of the appeal in the year 2016, the petitioner was regularly taking steps in the matter. And that is how we asked you to file the certified copy of the order sheet of the OGLS appeal number 2 of 2016. Right? The order which you are challenging is dated 1/11/2024. 1/11/2024, the counsel for the petitioner is absent. Then previous order 6/9/2024, the counsel for the petitioner is absent. The previous date 21/6/2024, the conducting counsel for the petitioner is absent. So
Before that also 2019-21, you remain absent.
COVID time.
कोविड टाइम छाड़ दियंतु 2024 रे जून मास परे तीनटा डेट हला गोटे होची 21/6/2024 गोटे 6/9/2024 तापरे हला 1/11/2024 जो दिन आपनकर डिसमिस कले तो तीनटा डेट रे ना पिटिशनर थिला ना काउंसिल थिले केही थिले.
So in fact, the court has suffered the documents from the collector. Till today, till the date of disposal also, record could not be obtained from the.
You are finding fault with the other side. What about you? You should also go and appear, na?
कारणटा देइछंदी जो जे collector has dropped the case as not possible to issue pata in favor of the appellant and reason has been assigned. So you have filed an appeal challenging that order. So you are to substantiate how the order passed by the collector was wrong. And if you will not remain present and continuously, then what he has to do? He said that the case is dismissed, non-appearance and order requires no interference. So what is the fault he has committed? The Revenue Divisional Commissioner.
In this, I have already filed my reply note. Government has not filed a reply. Is that last time, from 2016 till
ଆପଣଙ୍କର 6 ରେ ଯୋଉ ଅର୍ଡରଟା ମଧ୍ୟ ପାସ୍ ହେଇଥିଲା ସେଥିରେ ମଧ୍ୟ ଲେଖା ହେଇଥିଲା ଲାଷ୍ଟ ଚାନ୍ସ ଇଜ ଗିଭେନ୍ ଫର ଆପିୟରାନ୍ସ ଅଫ ଦି ପିଟିସନର ଆଣ୍ଡ ସବମିଶନ ଅଫ ଡକୁମେଣ୍ଟସ କେସ୍ ଇଜ ପୋଷ୍ଟେଡ ଟୁ 1/11/24 ଏବଂ ତେଣୁ ସେଦିନ ନା ଆପଣ ଥିଲେ ନା କୌଣସି ଡକୁମେଣ୍ଟ ରହିଲେ ତେଣୁ ତାକୁ ସେ ନୋଟ କଲେ ତେଣୁ ତାପରେ ଡିସମିସ୍ କଲେ.
that was not within my knowledge. But the record was not.
ଆପଣ କେସଟା ଫାଇଲ କରି ଘରେ ବସିଲେ କଣ ହବ ନଲେଜ କେମିତି ଆସିବ?
ମୁଁ ସେ ରେକର୍ଡ ଅଫିସ ଯାଇ ରେକର୍ଡ ଆସିନି ବୋଲି ଆମେ ଆର୍ଜନ କରିଦେବୁ.
3ଟା ଡେଟ୍ କଲାଣି ଆପଣ ଡାଏରୀ ତ ମେଣ୍ଟେନ କରୁଥିବେ ନା ଯେତେବେଳେ ଆପଣ ଯେତେବେଳେ ଲେଟ୍ ଅସ୍ ସେ ଦି ଅନ୍ 26/4/2024 ରେ ଲେଖା ହେଇଛି କଣ୍ଡକ୍ଟିଂ କାଉନସିଲ ଫର ଦି ପିଟିସନର ପ୍ରେଜେଣ୍ଟ. ସେଇଦିନ କେସ୍ ରହିଲା 21/6/2024 କୁ ତ ଆପଣଙ୍କର ଡାଏରୀରେ ଏଣ୍ଟ୍ରି ହେଇଥିବ କରିଥିବେ ଆପଣ ଯୋଉ ପର୍ସନାଲ ଡାଏରୀରେ ଆଡଭୋକେଟ ଏଣ୍ଟ୍ରି କରିଥିବେ 21/6 ତାପରେ 21/6 କେହି ରହିଲେନି ତାପରେ କଣ ହେଲା ବୁଝିବା କଥା ତାପରେ ଡେଟ୍ ରହିଲା 6/9 କେହି ରହିଲେନି ପୁଣି 6/9 ରୁ ଲାଷ୍ଟ ଚାନ୍ସ ଦିଆହେଲା 1/11 ସେଦିନ ବି କେହି ରହିଲେନି ତ ଆପଣ କହିବେ ମୁଁ ଜାଣିନି ଆପଣ କେମିତି ଜଣେଇବ ରେଭିନ୍ୟୁ ଡିଭିଜନାଲ କମିଶନର କଣ ଲୟର ଘରକୁ ଯାଇ ଜଣେଇଥିଲେ ଯେ ଆଜ୍ଞା ଆପଣଙ୍କର କେସଟା ରହିଛି ଆପଣ ନ ଆସିଲେ ମୁଁ ଶୁଣାଣି କରିପାରିବିନି ତେଣୁ ଆପଣ ଦୟାକରି ଆସିବେ. ପଠେଇଥାନ୍ତି ଗୁଜୁରାତି ପଠେଇଥାନ୍ତି ନିମନ୍ତ୍ରଣ କରିଥାନ୍ତି ଆପଣ. ହଁ ଲାଷ୍ଟ ଚାନ୍ସ ଦିଆଯାଏ. So we are fixing a date, you go and appear and participate in the hearing. So that
We are doing it because the order is not regent one. So therefore we are giving.
the land counsel for the petitioner has filed the certified copy of the order sheet of the OGLS appeal number 2 of 2016. The Court of Revenue Divisional Commissioner Central Division Cutter with a memo which is taken on record. On perusal, of the order sheet, it appears that the notice was issued to the parties on 21/10/2016. Including the concerned Tahsildar and collector. And thereafter, the case was posted to 23/12/2016, 10/2017, Seven for 2017, 26/5/2017, 28/7/2017, and on all those dates, the PO was busy otherwise. That is how the case could not be taken up. On 11/10/2019, the petitioner's counsel was not present. So also the opposite parties and the LCR was not received. And that is how the Tahsildar Bhubaneswar was asked to submit the LCR. On 5/2/2021, the counsel for the petitioner was absent, and on the next date, that is on 16/4/2021, the counsel for the petitioner was present, but since the LCR was not submitted by the collector, a reminder was sent. Thereafter, thereafter the case was taken up on 26/4/2021, and the petitioner was present, and he also filed the written note of submission. However, since the LCR was not received, in spite of reminders, another reminder was sent. The next three dates, that is on 21/6/2024, 6/9/2024, and 1/11/2024, the counsel for the petitioner was not present. And it appears from the order dated 6/9/2024 that last chance was given for the appearance of the petitioner and submission of documents. And on 1/11/2024, when the case was taken off, the Revenue Divisional Commissioner, Central Division Cutter, passed the interim order on the basis of the plaint and records submitted. And the collector's order was confirmed. The Land and Council for the petitioner submits that the order sheet would indicate that most of the time the case could not be taken up. Either the presiding officer was busy otherwise, or for non-receipt of the LCR. And some dates the petitioner's counsel was present, and the last 3 dates, the petitioner could not take steps inadvertently, and the petitioner is now ready and willing to cooperate with the court for early disposal of the OGLS appeal, and therefore he may be given a chance to contest, to place his case before the court. Or the land counsel for the state, who has no serious objection to the prayer made by the land counsel for the petitioner. Accordingly, the informed order dated such and such is that is 1/11/2024, passed by the Revenue Divisional Commissioner Central Division. Cutter, passed in OGLS appeal number, is hereby set aside. The petitioner is directed to appear before the Revenue Divisional Commissioner Central Division Cutter on you appear on 16th appear on 16th of May 2025, and he shall not seek for adjournment of the case, and cooperate with the Land Revenue Divisional Commissioner for early disposal of the appeal, and every step shall be it should be ensured that the appeal is disposed of within a period of 3 months from the date of appearance of the petitioner. It is made clear that if the petitioner does not appear before the RDC cutoff on 16th May 2025, the order dated 1/11/2024 shall stand confirmed. Copy of the order be handed over to the Land and Council for the state, who in turn shall intimate the opposite parties to take steps on that day before the RDC. Yes, disposed of.
Item 8.
In this case, I am referring to the OA application filed before the tribunal.
You are supposed to give the order dated 20th January 2017, passed in repetition number 20770 of 2016. Last order, just see. Last order, last line.
Last order.
Last order.
You have not gone through the order which was passed on the last date?
22/4/2025. Just see the order.
Are you having the copy of that order?
Copy of the order will file.
Just check it out. Just.
Go through the order sheet. When it is uploaded on the very day you are supposed to go through the same. The order has been passed that let the Land and Council for the petitioners produce the copy of the order dated 21/2017, passed by this court in WPC number 20770 of 2016. And that is how it has come today.
So today, on that day, it was fixed to today for further hearing in the.
Not further hearing, we, after perusing and hearing all these matters, we want to see that particular
You
order.
took the ground of limitation, saying that the order you.
Copy of the order is not available with me. at
In your
present.
case, how can you say so?
You are computing limitation from that day, saying that this court has given you liberty to file OA. Show us whether liberty is granted or not.
The copy of the
Just
order is not
reading that
available
paragraph.
with me at present.
which
I
was withdrawn on
the case because
The learned counsel for the petitioner submits that the copy of the order dated 21/2017 passed in WPC number 20770 of 2016 is not available with him
at present.
at present, and he will take steps to verify if the from his client as to whether the said order is available with them or not. Put up this matter on such and such date. The records of WPC number 20770 of 2016 be placed on the next date. Yes.
Item 9.
My lord, the copy of the order that may be office may be directed to put up the old record.
We are placing the records next date. That is how we have asked. But if you get it, you file it. Otherwise, we are directing the office to place that WPC record on the next date with this. Yes, next.
Since it is not available at present, I will
That we have noted down that you are telling that it is not available, but you will contact your client if it is available. It's well and good. Otherwise, we are placing this records on the next date. Yes. Item number 9.
I don't know. I feel for after that.
Yes, next.
Item 10.
On behalf of Mr. Ellen Pedman, they could solve the problem.
Yes, after vacation. Next.
Item 11.
My lord, police person on the my lord, without giving any compensation, she has to granted in compensation as given notice under Annex 2 for eviction of the construction of the petition was now. My lord, last occasion, loan council for the state has been directed to obtain instruction. My lord.
Annexure 2 reveals that you are in unauthorized occupation of the
That is a
land
property of DT. The petitioners are Marpata.
and you were asked to vacate the place by 17/12/2024, and or else the structure standing therein would be demolished on 18/12/2024. So
structure is still there or not?
took up that matter on 11/4. By that time, more than 3.5 months had passed. That is how we asked the London Council for the state to obtain instruction about the status of Annexure 2. What has happened, Mr.? ऐसे कौन अच्छी structure ना
Otherwise, the market there, my lord.
Structure is still there or not?
Structure demolished, my lord.
Demolished.
So,
Baranada Hungary.
and it was
code election important. There was a building over the plot.
the cost was estimated 8,86,200, and the
And the land cost was estimated to so and so.
and it was deposited with the
Land cost deposit kale koti.
ସବୁ deposit.
Endowment commissioner ko pakhre.
ନା ଏଣ୍ଡାମେଣ୍ଟ କମିଶନର କୁ ଚିଠି ଦିଆ ହେଇଛି, ସେମାନେ ଲ୍ୟାଣ୍ଡ କଷ୍ଟ ଦେବେ, ବିଲ୍ଡିଂ କଷ୍ଟ ଏମାନେ ପାଇବେ. No response, my lord. Now the endowment commissioner has to.
No, just a minute. Land is recorded in the name of Durga Thakurani Bijay so and so, Gopinath Sahu so and so, on the claim of Rajesh Kumar so and so, had issued a letter to the commissioner so and so to issue NOC if the plot is in the law, but no reply has been received. However, another issue so and so, Deputy Commissioner of Endowment so and so, has clarified that all the religious and the properties are coming under the purview of so and so, unless contrary is proved. Also stated that revenue records reflect deity's name, meaning thereby the property has been endowed to the date. Okay, on whatever the acquired area was clear for a construction of 19. The compensation voucher of rupees 1 so for plot number 1 has been submitted to the superintending engineer NS division for payment of the to the landowners so and so. So you approach the There must have been a valuation of the lands, also the structure.
My lord, that is at annexure, 4 series, page number 22.
4 series.
My lord. Page number 22.
22. Read petition, no?
My lord.
Yes.
Serial 11. Land
11 টা কেতে? Land cost.
Land cost.
এটা তো জীব সেটিকি ডেটিং আক্রস
My lord.
স্ট্রাকচার
Building cost.
7,10,000 379
My lord.
এই টাকাটা এমানে পাইবে it already deposit is you make necessary application so that
My lord, that order.
ଏଠି ପ୍ରୋବ୍ଲେମ ହଉଛି ଏଣ୍ଡାମେଣ୍ଟ କମିଶନର କ୍ଲିୟର କରୁନାହାନ୍ତି ହଁ ଏଣ୍ଡାମେଣ୍ଟ କମିଶନର ଇଜ ନଟ୍ ଆନ୍ସର
No, he has application to endowment commission.
ନା ନା
He will follow due process of law for the
Yes,
purpose
yes.
of realization. That has been already been.
commissioner of endowment is a party so he has to file the appropriate application before the concerned authority. Money has been deposited, so obviously the structure value is to be paid to him, right? So, even if it is an unauthorized structure and the government, the date is land, so the land first will be taken by you and
Yes, my
the
lord.
structure value left on.
You are appearing for endowment commissioner. Yes.
As for the order dated 11/4/2025, the Land and Council for the state has produced written instruction dated 5/5/2025 received from Tahsildar BRD, opposite party number 6, in which it is stated as follows. Pura quote kar diya. Stop. Since compensation amount has already been deposited, the petitioner can stay before the concerned authority for payment of the structure cost. Na kaun se da koi jandi structure cost.
building cost
Code lekha hai
page 22 serial number 13
the building cost in his favor. Stop. With the aforesaid observation, the writ petition is disposed of. Building cost empty level as per annexure. Should I get the annexure? Annexure 4
series.
Annexure 4 series. Yes.
Item 12.
Item 12, I play 1 week more time to file the IMI.
All right, 1 week time to file the interim application after summer vacation. Yes.
Item 13.
Mr. Amit Kumar Nath, Land and Council, appearing for the endowment, that is opposite party number 4, the Commissioner of Endowment, Orissa Bhubaneswar, submits that the counter is ready and it will be filed by tomorrow, serving copy on the Land and Council for the petitioner. The Land and Council for the petitioner is at liberty to file rejoinder, if any, put up this matter. Just delegate, make them solve. Serve in court. Then tomorrow aji to file kar debe, you'll file the answer in course of the day. Copy of the counter affidavit has been served on the Land Council for the petitioner in court today. You seek some time to go through the same and file the affidavit. Put up this matter after ensuing summer vacation. Yes, next.
Open.
Yes, order dated 25/4/2025.
Yeah.
25/4/2025. There is a direction to serve copy to the council for aims to take instruction. Despite of that, they are not refusing to.
Lordship, we have gone to AIMS to serve the copy. They said we have not engaged any council. Union of India Council will represent us. So that is why there is a memo filed by the council concerned on behalf of the petitioner stating that AIMS denied to receive the copy. They said Union of India has provided us and Union of India will represent us.
Mr.
There is
Pali,
no council.
where is Mr. Pali?
Petitioner cannot say that they have not served copy. That's why they can say.
He has filed a memo.
Where is that memo?
Let a memo cross also that.
The memo is there, so.
Let a copy memo solve the. Who have denied the authority, who have denied that.
Mr.
For
Pali,
the direction
council
of
is
the
there
swan,
to receive the copy.
compliance of the order, I visited the office of the swan, so to solve
Yes,
the
my lord.
extra copy of the writ petition. As the council was not found in the court premises, I made the legal officer of the AIMS and give the copy, but he refused to accept this answer and stated that the counsel for the Union of India will conduct our case matter to whom we have already served the copy. in the-
We have received the
Okay,
advance
then.
copy, ma'am.
Okay.
you will represent for AIMS also?
Yes, if the Union of India is there, we can appear for AIMS. For all.
No, Union of India is there.
Then we'll appear
but-
for all. AIMS and Union of India both.
All right. Peruse the memo filed by the Learned Council for the. Who has filed this memo?
My lord, myself.
Petitioner.
Yes, Lord.
At the Learned Council for the petitioner, wherein it is indicated that even though the copy of the petition was offered to the legal officer of the AIMS, but he refused to accept the same and stated that the Council for Union of India will conduct that case. The The Learned Council, the Learned Deputy Solicitor General also submits that he will conduct the case on behalf of the AIMS, that is opposite party number 2, 3, 4, 5,
2 to 6, Lord.
6.
1 to 6, my lord. So we reflect 1 to 6.
नहीं अपन तो यूनियन ऑफ इंडिया में अपोजिट पार्टी नंबर 1 for 2 to 6 also. Hello. Yes, what is this matter?
They challenge the order of the Central University Tribunal, ma'am. Last occasion when my brother said that my lordship is not accepting his argument as regards to the maintenance writ petition is concerned. Let's be satisfied about this.
We in that order dated 25/4/2025.
Lordship.
The council.
Lordship.
We have mentioned that when we posed a pertinent question to the
Correct.
Learned Council for the petitioner as to whether any such persons whose cases prayer for regularization was rejected by the Learned Central Administrative Tribunal have approached this court
Lordship.
challenging such order or filed any application before the Central Administrative Tribunal for review of
Lordship.
such order. He
In
will
fact,
submit that the observation made by the Learned Tribunal that cases of similarly situated persons with a prayer for regularization has been rejected by the division bench is an error of record and no such order has been passed. That was your
Lordship.
submission.
In this regard,
So,
may I submit, Lord?
Now you stick to your submission, or you have a different story
No,
to
no,
tell?
the same stand, Lordship. I am only
Same
adding
stand,
to
okay.
clarify that as per the direction of the tribunal, the authority concerned, that is AIMS, passed a speaking order rejecting my regularization. That speaking order was challenged in second round, which was set aside and matter was remanded back because the order was very cryptic. There was no reason. So AIMS was directed to reconsider the case by another order, which is annexed here, Lordship. That is, kindly see the order.
No, we have seen that you are challenging now the order dated 19/2/2025 of the Central Administrative Tribunal, right? But in that very order, something has been mentioned on which we wanted to.
That is what the observation made by the tribunal is extraneous. That is what I stated last time also. Because
so, Mr.
both
Pari,
speaking
please
order is under
verify
challenge.
that impugned order where it is mentioned that if you come to paragraph number 11, towards the in page number running page 36, internal page is 14. Are you coming to that page, particular page number 14 of annexure 1? The impugned order is annexure 1.
Yes. Internal page.
You can come to page 14. Please come to the page 14.
My lord.
Internal page 14.
Yes,
Ajay, now you come to the fourth line from the top.
yes.
Be that as it may. So, since the earlier division bench, you got it that?
Yes, I got it.
Be that as it may, since the earlier division bench have already rejected the prayer for regularization of the persons who were appointed on such contractual basis with consolidated remuneration, and it is the specific case of the appellant that they have been similarly placed situated like the applicants in the earlier way, we find no distinguishable ground or reasons to allow the prayers once so. What he says that there was no such rejection order of regularization of the, and this is an error of record. So we wanted to know from him that whether any such case has been rejected, and if it has been rejected, whether any review application has been filed before the Central Administrative Tribunal or it has been challenged before this court. So you must have information as to whether such thing has been done or not.
Case that is an error on apparent of the record. He has to file a review and get it clarified. Why should we interfere?
He has not filed any review.
Yes, he can file it.
My lord, chart.
Lordship, we have prepared a consolidated chart for convenience of this court.
Yes, Mr. Panigra, if you are saying that this part of the recording of the tribunal
Lordship
is error on apparent on face of record, why don't you file a review and get it clarified?
Lordship, I am adding to that the direction. There was no order for regularization. There was a direction for consideration for regularization. That
so why don't you tell in the review jurisdiction? You won't tell that tribunal by filing a review.
Lordship, then if that be the case, then Lordship may set aside this order and
disposed of.
Sir, the total first page total case 11 case file staff not
set aside does not arise. If they prefer to file review, there is no bar. They can file and clarify this. You can go and file a review petition.
Lordship, because this is a order regime. They said regularization was rejected, but the order was the direction was that to consider the regularization. I was placed similarly. I should have been given the same direction, same opportunity.
Okay, you can go. You can tell those things to the tribunal by filing a review.
Because Lordship, the review jurisdiction is very limited. So therefore, I am saying when the order is cryptic, the order is extraneous. So this needs to be set aside. Otherwise, on the face of the I am two order I have annexed here.
If on similar point, similar situation, earlier cases have been disposed of, it is not necessary that every time he has to pass a 100-page order. It is a wastage of court's time.
No, I am saying the
principle has been decided by a court that under these circumstances, this type of persons are not entitled to get relief.
No,
so you are not entitled. Matter ends there. You say that my case should be separately dealt.
No.
All these things. How many times that type of order?
Lordship, kindly see for a moment. Kindly see Annexure 10.
Yeah.
Annexure 10, page 94. Lordship, for a moment.
No, you have made a submission and it has been recorded in our order, judicial order, You made the submission that it was an error of record. Now this, you are for the petitioner.
So, no.
Now this man, it is filed that as many as 8 ways have been disposed of
Lordship,
by the common order.
may I submit,
So,
Lordship?
these are on 2018, 2019. So these cases have been disposed of. So,
With your kind permission, Lordship, may I submit?
Base cases.
huh?
This is
Lordship,
the
may
base
I
cases.
submit with your kind
Total is
permission?
not the same base cases.
What happened then?
1 to 7 dispose of common order passage.
What type of order was passed?
Lordship, that
already
is what
in favor
I'm
of the
saying. Page number 110, kindly. For a moment.
In favor of the applicant.
Order in favor of the
Applicant. Annex Annexure 4 and Annexure 10. The order already passed in favor of the applicant.
Let us see that. Annexure.
Annexure 4, second
Annexure
round
10,
repeated
Lordship,
is,
second.
Annexure 10. Page number 9.
Page number
9.
Starting.
Last order.
90.
94.
94.
Annexure 10.
Who are these persons?
They are similarly co-petitioners, Lordship.
Yes, sir.
Batch of
Let us see.
cases. The operating person is starting from 116. 117 is the end.
116.
Lordship.
Here it is mentioned that in the impugned order dated so and so is hereby quashed and with a
Direction
direction to the respondent to consider the cases of the appellant
strictly as per
the order dated so and so and pass a reasoned order
communicated the
to
applicant.
communicated so and so.
Receipt of
So ultimately what happened?
this, so far they have not passed the order in one batches cases. On one single 2 cases they passed the order, which is challenged for the tribunal. Tribunal has dismissed the case. This is the impugned order before your Lordship.
Now, how many cases tribunal has ultimately dismissed the order after remanding the matter?
Only 2 cases, which is impugned here, Lordship.
Well, kindly see Annex 11. Thereafter,
Yes.
order for see Annex 11. Annex 11, page number 118 and 119.
What is that?
They have already accepted and 118. Fine. I'm right. Mr. Abhilash Mishra, Land Counsel for the respondent has submitted that the department are in process of complying with the order of this tribunal and taking steps for regularization of the applicant. Therefore, the praise for time to file reply. See, MA would file करते से या पर जब सेकंड ऑर्डर टा पास गला MA would file करते से कहले जे आउ 90 डेज टा शॉर्ट ना 45 डेज हमको दिया जाओ कारण डिपार्टमेंट रेगुलराइजेशन करिया पे ऑलरेडी करू
नहीं रेगुलराइजेशन करिया पे कोटी ऑर्डर
is page number 118
11 no court order कहीं
court order annex 10 जोटा
Annexure 10 में तो किसी लिखा ही नहीं Annexure 10 page 117 रे in paragraph number 16
मैले order ऊपर just वे लिखा है जी RA number 9 by 2023 in
117 ना कितने बोलें 117 ना 118
180
okay 118 रे this is state that it is in the process of complying the order of the tribunal. So which is that order?
That order is OA number 536 by 2021.
Where is that?
ऊपर लिखा है
ऊपर माने कोड या कोड पेज रे लिखा है
पेज कौन नदी
ऊपर लिखा है जी
पेज कौन नदी को पेज
अच्छा ये 117 पेज नंबर 117
17 नहीं
पेज नंबर 117
ওই নম্বরটা পড়েছি 94 পেজ রে 260/536 of 2021
common order চাই
হ্যাঁ সেটা কোন ହେଲା ସେ ଅର୍ଡରଟା ଲାଷ୍ଟ ପୋର୍ସନରେ কোন କହିଲେ
সেই অর্ডারটা করে সে কইলে যে আমি টেকিং দি স্টেপস ফর রেগুলারাইজেশন
ସେଟା ଡାଇରେକ୍ସନ ହେଲା ଯେ କନସିଡର ଦି କେସ୍ ଖାଲି କୁହା ହେଲା ରେଗୁଲାରେସନ ଆଜି ତ ଅର୍ଡର ହେଇନଥିଲା ଖାଲି କୁହାଥିଲା ଇମ୍ପୁଣ୍ଡ ଅର୍ଡର ଇଜ ସେଟ୍ aside with a direction to the respondent to consider the case of the applicant strictly as per the earlier order passed in OA number 570 of 2018. Where is that order 570 of
That is
2018?
annexure 4,
Annexure 4.
page 78.
এটা ବି ଗୋଟେ common order.
Lordship,
ଆଜି କଣ ହେଇଥିଲା operative part ରେ
page 78, Lordship, for a moment, kindly.
78.
Starting from 77:16.
para 16 ଟା ପଢିଲେ
In view of the facts and law discussed above, we do not find any ground to interfere in the matter. However, we are of the view that nurses help in the speedy recovery of patients are a vital resource of hospitals in as much as they are only resources available 24/7 for catering the patient's needs. They are directly involved in all aspects of hospital service quality, be it in the form of monitoring patients' recovery besides medication management and assistance with surgeries and other major operations. In some situations, they are responsible for performing immediate intervention to prevent medical complications. They are on the front line of administering and evaluating treatment and provide invaluable emotional support as they are best placed to understand the complexities and implications of having a serious illness. Considering the pandemic situation due to COVID-19 all over the country and the contribution of all health professionals like these applicants who are serving at the time of need, the authority concerns are impressed upon as a matter of exception to sympathetically consider the cases of the applicants by way of setting up a high-level committee with Secretary of Ministry of Health and Family Welfare, Government of India, as one of the member for considering one-time exemption for regularization of the applicants. The entire exercise of setting up a high-level committee and taking a decision on regularization as one-time exemption of the applicants may be taken within a period of 6 months from the date of receipt of the copy of this order. It is also directed that services of the applicants are not to be disturbed if the posts they are working have not been filled up until a decision of the high-level committee is not taken. With the above observation, the OAs are disposed of, but in the circumstances without any order to cost. The MAs are to accordingly disposed of. So this is the direction with all batches are disposed of. My cases are similarly placed. I was expecting same order from this court, but court has given it another direction that as there was no direction for regularization was not considered. Therefore, the case is dismissed.
Here also
there
there
was
is
no
no
such
direction. It
pleading.
is only for consideration.
consider
That is what I'm saying. I'm similarly placed. My case is also similarly placed. I may be also given. Why shall I be deprived of equality and equal opportunity? My case be
who are
considered.
those persons in those ways which were in that common order under annexure 4
Lordship, they are
contractual
co-petitioners. They are similarly placed. Contractual, all contractual.
contractual
similarly
losses
placed.
in AIMS Bhubaneswar
Lordship.
and these
The only thing is that their batches cases are came,
who are
came to
these
the
two
forum.
petitioners
They are also nurses. The OA are filed with the same year, 18 OA. This is also 18 OA. The only thing is that their batches came to the court listed directly. My cases are left out. Subsequently, it was added. I am similarly placed. I am expecting the same order because Article 14 and 16 is the foundation of constitutional foundation. And there is no such pleading from either side. Neither the respondent said that their case has been rejected. I said my OA was disposed of, earlier OA was disposed of with a direction. Let me same benefit, same direction be issued to me. I am similarly placed. But there is a twist given and with a extraneous reason that was dismissed. Only two before 2 OA which was dismissed, that is impugned before your lordship.
it has been ordered that it is one time exception
Lordship.
exemption of the applicant may be So that was the particular language used.
Has they complied with this order?
No,
Have they regularized anyone?
No, that is they pass a script again. The speaking order.
Their process of order.
Yes.
Let's see for a moment. Kindly see. There is a pleading. They out of 30 candidates, they have regularized.
Mr. Paddy. They are the proposing to do.
30 already 20 aguru କରିସାରିଛୁ regular person.
Are you proposing to regularize these people?
No, I didn't have any instruction for first time. I've gone through it and I have also not received any instruction in this regard. And I have gone through it. The 78 page they have read it. There is no validation or there is the that high level committee has function or not. What decision they have taken.
That is the exact reason.
If you have constituted a high level committee, these people are also similarly situated, you can consider their case.
After this order, whether the AIMS authority challenge the same people, the High Court, it is not known to me also.
No, Lordship, that is the peculiar facts that AIMS has not come to the High Court. None of the order has been under challenge.
Okay, Mr. Paddy, please take then instruction. As you are rightly telling that whether this order under Annexure 4 passed in so many original applications in which that order has been passed that to constitute a high level committee for taking decision on regularization, whether that is challenged or not, and if not challenged, since the order is dated 19/5/2021, whether any high level committee has been set up and whether they have taken any decisions on those persons who are the applicants in those original application, because according to the petitioner, they stand on the similar footing. They are also the nurses in the AIMS, like the applicants in those ways whose cases were disposed of under Annexure 4, that common order. Just a minute. The Learned Counsel for the petitioner placed a list of cases which was disposed of by the Central Administrative Tribunal in different original applications. The same is taken on record. The Land Counsel for the petitioner submitted that the petitioners are similarly situated like the applicants whose cases were disposed of by common order dated common order dated 19/5/2021 under Annexure 4. In the operative part of the said order, it is held as follows. पूरा paragraph 16 टाको operative न करी, the relevant paragraph is paragraph number 16 and 17, है ना? 16 टाको is quoted here in below. Entire paragraph 16 टाको.
Page 80.
हाँ?
Page 80. Page 80.
हाँ, page ऊँची नहीं, page ऊँची 77, 70. नहीं, 8 है ना? Operative part of paragraph 16
हाँ, 16, 80 sheet 80, 81
अच्छा, फिर पूरी बात पढ़ो.
देखिए
हाँ, है ना? The Learned Counsel for the petitioner submits that the order dated 19/5/2021 এটা 19/5/2021 ने पास ହେଇଥିଲା ବୋଲି ସେ ଡେଟ୍ ଟା କୋଉଠି ପାଇଲେ?
The order, Lordship, it is in the order itself, top of the order.
Top of the order.
Face, on the
Let
face.
us see.
We are relying on the bottom, on the face of it, the date has been quoted.
Just a minute. Just a minute.
1981. 1988. 1985, not 21.
The Land Deputy Solicitor General, Land Counsel for the petitioner submits that order under Annexure 4 has not been challenged before this court
By the respondent, Lordship.
by the respondents. Stop. Mr. Parhi, Land Deputy Solicitor General, wants to obtain instruction as to whether the aforesaid order under Annexure 4 has been challenged by the respondents before this court or not, and if not, whether any high-level committee has been constituted for taking a decision on regularization. Put up this matter after summer vacation. Yeah.
My lord, page number 73.
Next.
My lord, the second case is also similar to this case. First case is going to be Kashyap, second case Rajesh Mahapatra is there. That's both.
I'm here also.
Acha, ठीक है.
But here also, I think the order annexed numbers will be changed because the variation is there. In the second case, they have made those annexes, but annexed numbers are different.
Annexure number different.
Number of
Second.
कितने कौन आती?
Book different. 4/5.
हाँ?
Set Annexure 5.
500?
आया.
ट्राइब्यूनल जो ऑर्डर था?
हाँ.
अच्छा, जो सेकंड था माने ये जो नमिता बारिक रे,
आया.
नमिता बारिक रे सेटा वो Annexure 4 जगह रे जो Annexure 5 है ना, बाकी सब समान रहिबो और एटा आसीबो ता संगे लिखि देलो है ना.
One thing, Lordship, in that there I am
yeah,
appearing
there
for
Mr. Rajesh Mahapatra na लिखियो second था. It is a central government council.
Yes,
central government.
Senior
I'm
panel
appearing
council.
for all the
Senior
opposite
panel
parties.
council, Kashyap was senior panel.
In the first one, Satya Sundar Kashyap,
And second,
senior count.
yes, senior panel council.
Senior panel
Rajesh
council.
Mahapatra is senior panel council.
Okay.
Let's say in that second case, I'm appearing for all the opposite parties, but let's say mention only OP one. It's not right. My appearance is for all the opposite parties.
No, you are supposed to appear because now the AIMS says that our case will be conducted by the Union of India. So obviously, you will. Next.
Yes,
Your Lordship, if you permit me, I want to bring your attention to page number 73 for a moment, Lord.
No further submission. Make your submission reserved for the next.
Okay, Lord.
Sir.
Yes.
Okay.
Item 16.
Yes, item 16.
Officers are the civil type persons. Permanently residing at village Lankagula. The village name is Lankagula.
See your prayer.
Yes, sir.
Prayer to award the compensation in respect of the structure. We will not award in the writ petition. We are not here to give award. To see the prayer.
Directly opposite parties.
Representation pending achieved. Representation pending before the collector.
Collector. Here not admittedly we are the permanent resident Lankagula. Entire Lankagula village has been acquired. We are the unauthorized encroacher. There is no dispute about it. Our name also finds place in the list. There is no dispute about it. But till today, they are not releasing the cost of the structure as well as streets and other benefits.
Annexure 5 is the representation. Representation highlighting the Swansea. He has submitted a representation of the Swansea, the petitioners under Annexure 5. And what is the date of the representation?
That not 19/3/2025.
19/3/25.
18/3.
18/3. Sorry, mal
18/3/25 बोले they must be होनी for a sled. Dispose of in accordance with the time limit देवें है ना sir. Next.
Item 17.
That's item 17. Mr. Samal,
May I please?
এইটা কোন ছাড়ি বলে না সেই কেস education.
Regarding non-payment of the non-providing the R&R benefit, the petitioner had approached this honorable court once. Under Annexure 8, your lordship directed to consider my representation under Annexure 7 and dispose of the matter. But while disposing of the matter under Annexure 9, they have not taken into consideration the averments made in paragraph 8 of my representation under Annexure 6.
No, what they have ultimately.
They have denied to provide any R&R benefit
On what ground?
on the ground that at the relevant point of, at present, the provision, there is no policy for providing the employment to the land.
This was the reason. Which,
Your lordship, may kindly have a glance to
Annexure 9.
Annexure 9, page 39, clause 3. All the three applicants are claiming employment against the land acquisition of their ancestor by relying a circular issued by the railway board in the year 2006, whereas the land acquisition was done more than 5 decades ago by the state government, not by the railway. It is mentioned that the land was acquired by the state government 5 decades ago, and further the land was transferred by the state government to the railway in 1993. Railway taken over the land in 1993. It is, if this land was initially acquired for the Rourkela steel plant in 1954. In 59, Rourkela steel plant surrendered the land. This is no more required. This land is surrendered. Instead of returning to the landowner, the state government in 1993 gave this land to the railway department. Even in 1993, there was circular that if the railway will take the land of some persons, then they will provide the employment. They have neither paid the company. Of course, I am not.
Come to paragraph number Roman 5.
My lord.
In all these claims of employment, there was no policy at the material time of providing employment to the land losers in the railways.
Your
The
lordship, I have
instruction issued subsequently from time to time were applicable prospectively. Applying the policies retrospectively is likely to lead an incomprehensible situation and unfathomable magnitude of the policies issued at a later date cannot be applied in cases of land acquisition made several decades ago. Further, the policy of offering job to the land losers whose land was acquired for railway projects has since been withdrawn by so and so. এই circumstance আপন কেমন দেবে?
Your lordship, may kindly have a glance to page 25 annex.
No, the fact remains, in lieu of the land being acquired in 1950s,
My lord.
you are seeking RR benefit. You are saying that it was not put to use. Railway has taken over in 1993. Therefore, you are
Yes.
entitled.
We
But
are
the
saying
reasoning here is, since the acquisition took place in 1950s,
50, the railway had not taken the land in 90.
that's it.
Their place is-
Possession is something different. But
Yes.
the fact remains that the acquisition in lieu of which you are seeking RR benefit is in 50s.
That is by the state. If my land would have been utilized for the purpose of
No,
Rourkela
you
steel
can-
plant for which it has been acquired, then the RSP would have given me the R&R benefit. There is a policy of the Rourkela steel plant to provide the R&R benefit. Since the Rourkela
But
steel
at that point of time, you could have come in 1950. 1950 ରେ ଆପଣଙ୍କର ଯଦି
they have surrendered the land. Against whom will claim the benefit?
no, when they surrender, you are not giving the
93. They have admitted.
if what we are doing till 93, why you have
You
come in
took
2020?
possession over the land.
No, no.
It was no way interfered with
Possession
land.
is different matter. You have received the compensation amount. If you are claiming the this employment and your land has been acquired and it was supposed to be given to the Rourkela steel plant, who has some kind of scheme to
Your
give
lordship, may kindly
employment.
have a glance
Hey,
to
first
page-
time you raised the grievance in 2024 by giving a representation. 2024.
My lord, no. In 2006, there was an economic blockade in Rourkela. All the authorities, SAIL, railway, and the state government, they decided that
they will provide employment to all the land users.
Okay, 2006.
2006.
Still you remain silent till 24.
We have made several correspondence with the-
Unilateral correspondence will not.
Your Lordship, I have specifically stated in paragraph 8 of my.
All right, we don't.
Your Lordship may kindly have a glance.
Are the learned counsel for the petitioner. It appears that the petitioner previously approached this court in WPC number so and so, and direction was issued without expressing any opinion on the merits to the opposite party number 1, Chairman, CEO, Railway Board, Ministry of so and so, to take a decision on the application of the petitioner and pass appropriate order in accordance with law. In terms of the order, the following order has been passed, which is annexed as Annexure 9. Annexure 9 order का पूरा quote कर देना है ना. After going through this thing, we find no infirmity or legality in this one. Therefore, we are not inclined to interfere with the same. Writ petition stands dismissed. Yes, next.
Can I bring your Lordship to the Annexure 5, page 25?
Oh, sorry.
Applications are there.
Yes, next, item number 18.
Item 18.
are same.
Same.
We all are appearing.
Give the name it will give.
Published.
Yes, next.
Item 20.
Item 20.
The petitioner's mother was declared the beneficiary to receive the compensation, 7 lakhs. So during her lifetime, before death, she has received 2 lakhs. So for claiming balance, my lord, 5 lakhs, this honorable directed to settle the claim as per order was passed, my lord, 18/9/2024.
You are challenging on Annexure 12.
Challenging and page 33, admitting the fact of the petitioner's grievance.
Come to page number 34.
34. Now the petitioner is claiming the balance RR amount of his deceased mother, whereas he has already received his RR assistance as separate family from his mother. But in the Orissa Rehabilitation and Resettlement Policy 2006, Section 2F, it is clearly mentioned that a major son will be considered a separate family of RR benefit. Going for the representation of the petitioner, report of the project director, RR, LSIP, Balangir, and available documents, I am led to conclusion that the petitioner has already received his share, rehabilitation and resettlement benefit as separate family. Since the compensation of a separate family is non-transferable to another family, hence the representation petitioner cannot be considered eligible for payment of compensation as provided under ORRP 2006. I am of the view that claim of the petitioner does not have any merit, hence it is rejected.
Yes, what is wrong?
Yes, my lord. My lord, the petitioner's mother, I am praying, I have been paid the benefit of myself as per section 2F of the RR policy. There is no doubt.
Yes.
But now I am praying, the part payment is made in my mother's name. So out of it is calculated.
How can you receive 2 type of payment?
No, my
For a
yes.
family, what you are entitled to, you will get it.
No, my it is a property under Hindu Succession Act 15, 14 and 15.
Yeah.
Into RR section 26, my lord. 26.
You have to go by policy. Policy cannot be interpreted on the basis of some statute.
No, my policy said in the one family.
Yeah, are you reading the policy? Are you reading the policy?
Policy, quoting 2F. Each of the following categories will be treated as separate family.
Yes.
For extending rehabilitation benefit under this policy.
Yes.
A major son, grandson, irrespective of his marital status. So under section 2FI,
Yes.
I was declared as the separate family and my compensation 5 lakhs is paid to me. So during my lord the formulation of the list of beneficiary, my mother was considered and she was declared as a beneficiary. So after she being declared a beneficiary, part payment is made, but thereafter when she was to get the further amount, she died. So my lord, page 22, Annexure 5, page 22. So it is out of
Which page you are pressing?
my lord, yes, RR Police 2006.
Page number.
Yes, page 187. 187.
157.
Eight for family.
2A. I minor. Note,
Hmm.
each of the following categories will be treated as a separate family for the purpose of extending rehabilitation benefit under this policy. A major son, grandson, irrespective of his marital status. So the petitioner, Nityanand Bag, was declared as a separate family, having the status of being major son and married. So I have been paid my benefit. So my mother, Vasanti, my mother, the list they have prepared.
Where is that list?
Where yes. My name, mother's name, page 21, Sumitra Bag, page 21. Again, serial number 328. 328. So 7 lakhs payable, out of which 2 lakhs something is payable. So balance.
What portion?
Again.
Like payable code लिखाई.
They did minor. So the admit question impugned order, they out of 7 lakhs, 2 lakhs paid. Is page 30, page 33 re. Impugned order.
Impugned order.
Minor, page 33, bottom to next page. The petitioner has submitted that his mother Sumitra Bag was listed at serial number 328 of the affected and displaced family of village Khunpodi under resettlement policy 2006. On dated 14/3/2018, his mother received 2,72,000 out of 7,56,000 as first installment deposited in her account. On dated 5/3/21, his mother died, and the rest compensation amount 4,84,200 have not been paid to her. So this is my
continue.
Yes, my lord. The petitioner's claim is that being the only son of deceased Sumitra Bag, he is entitled to get the rest compensation as the legal heir and successor. The project director, R.R. LSIP Balangir, stated that rehabilitation and resettlement assistance to both Sumitra Bag, deceased mother petitioner, and Nityanand Bag, petitioner of village so as per R.R. Policy 2006 under Lower Sukotal Irrigation Project, Balangir had been sanctioned and communicated that office by letter dated so dated 8/5/2017 of the director R.R. Secretary to Government DOW Odisha Bhansha. It has been clearly mentioned there, sanction order that R.R. assistance should be released only after evacuation of the displaced family. However, to facilitate the evacuation of the cost of house site, cost of house building assistance and cost for temporary shed shall be released in the first installment. The cost towards the agricultural land, maintenance allowance, and transportation charges, if any, should be paid only after evacuation of the displaced persons from that acquired land. Accordingly, 2,72,000 was paid to both the petitioner and his mother on 13/3/18 prior to evacuation process, but the petitioner's mother died on 5/3/21 before evacuating the village. मैं एबीसी नहीं है पूरा डिस्प्ले आई हैव बीन से जो yes my village. Next para. Now the petitioner is claiming the balance RR amount of his deceased mother, whereas he has already received his RR assistance as separate family from his mother. But in the RR Policy 2006 Section 2, it is clearly mentioned that major son will be considered separate family of RR benefit. So going through the representation petitioner, report of the project director, RR Balangir, and available documents, I am led to the conclusion that petitioner has already received his share. I have received my share.
Yes.
And we have this settlement benefit as separate family, since the compensation of a separate family is non-transferable to another family. Hence, the representation of the petitioner.
Mr. Nayak, the mother was treated as a separate family. He was also treated as separate family. He has been already paid. So far as the mother claim is concerned, it was partly paid 7,56,000.
2,72,000.
2 lakh. So rest amount he is the only legal heir. That is a submission. We do not know whether.
Yes, legal legal
legal heir.
Legal certificate, page 25.
Annexure
8.
Annexure 8. It allows Mitra Bagacha is the only one. All right, Lekhun.
It is only 2 lakhs something.
This petition has been filed by the petitioner, Nityananda Bar, challenging the order dated 21/11/2024 passed by Collector Balangir in Miskis number.
Test case, let us put it in the local. Let us see, understand how they are very small amount. Taking out local.
56 of 2024. Stop. It appears that the petitioner earlier approached this court in WPC number 22695 of 2024. Which was disposed of as per the order dated 18/9/2024 with a direction to the Collector Balangir, opposite party number 2 to take a decision on the representation filed by the petitioner and to pass appropriate order in accordance with law. The collector in the impugned order has been pleased to hold that as per section 2F of Odisha Resettlement and Rehabilitation Policy 2006, the petitioner being the major son is to be considered as a separate family for the R&R benefit, and the petitioner has already received his share of R&R benefit as separate family. And therefore, he is not entitled to get the compensation amount of a separate family, as it is non-transferable. The learned counsel for the petitioner submitted that the petitioner's mother, Sumitra Bag, was listed at serial number 328 of the affected and displaced families of village Kuntapali under 2006 policy. And and she received a sum of rupees 2,72,000 out of rupees 7,56,200 as the first installment deposited in her account. However, on 5/3/2021, the mother of the petitioner died, for which the rest compensation amount of rupees 4,84,200 could not be paid to her. The Learned Counsel for the petitioner further submits that the legal heir certificate under Annexure 8 would indicate that the petitioner is the sole legal heir of the deceased Sumitra Bag and is entitled to get the rest compensation as legal heir and successor of his mother Sumitra Bad. And though the petitioner, being a separate family, in view of the definition under 2F of the 2006 policy, has received his share, but is also entitled to the balance share of his mother, and the collector Balangir has committed illegality in rejecting the representation filed by the petitioner under Annexure 12. The Land Council for the state shall obtain instruction, who is appearing for all the opposite parties, shall obtain instruction in the matter, and the matter will be placed in the Lok Adalat, which is scheduled to be held on 10th of May 2025.
You seek instruction on that day.
My lord.
At least the small amount you can, pay and finish it up.
Yes, next.
Item 21.
Yes, Mr. Jana.
Item 21.
Yes.
In these retreats of the petitioners have challenged the imposition of conversion fee and processing fee for the conversion of leasehold lands to freehold lands by making an amendment in the rule. It's a second amendment in the OGLS Rule 83. And the rule is always prospective. And in the statute, there has been no reference about this freehold conversion of the land to freehold. Therefore, the subordinate legislation has no authority to legislate on the subject. This is the short question of.
No. You have now made an application for conversion of the land from leasehold to freehold. So now the government has taken a decision that this would be the amount for conversion fees and this would be the amount for the consent fees. So in terms of that decision, they are charging it.
Well, the decision has been taken.
Yes.
That is the introduction of rules, second amendment rule. Kindly see page, that is 14/8/2023 rule. That is with effect from 14/8/2023.
Yes.
Annexure 3.
Yes.
Page 20. Revenue and Disaster Management Department notification 14th August 2023. 14 August 2023, it is always prospective.
Yes.
Short title and commencement. These rules may be called the Odisha Government Land Settlement Second Amendment Rules 2023. They shall come into force on the date of their publication in the Odisha Gazette.
Yes.
It was published on 14/8/23. My submission is it is applicable prospectively.
Yes.
If it is applicable prospectively, lease was granted to the members of the society on permanent basis. And thereafter, all the lands were mutated in favor of the leaseholders, and the pota was also granted during the year 87 to 90. Since it was made during the year 87 to 90, now imposition of conversion fee by
when you applied for the conversion?
Conversion after this 23.
The
So then-
date when you're applying
That is
for
relevant.
conversion, that is the relevant date.
It's not that if you would have applied earlier.
No,
that
not
would have been
applied
different.
earlier.
Then
Because the porta was issued in my favor
that's a different
and
matter.
the land was mutated in my favor.
Yes, yes, that's all right.
There was no necessity on my part to make it earlier, and there was no provision.
No, it's a
to-
leasehold land. You cannot leasehold and freehold. You know that what is the difference between the two. So for the conversion, a new rule came into force, as you said, under annexure 14/8/2023. And thereafter you are making the application. It is not that prior to that you are making application and
No,
they
not
are-
that prior to that. That is prior to that, there was no necessity to make an application for conversion of the land to freehold.
Now you are getting a transferable right, transferable marketable right. So
No, previously it was there also.
that's right, but the leasehold, it's a complete freehold now. So therefore, the
The-
rule
the-
applies to
the
you.
Terms of the lease was also, it is permitted to be sold by the lessee.
No, you get an
I can produce
absolute
the-
ownership by this.
I can produce the lease deed where
This is applicable.
the lessee was permitted also. My submission
that would be subject to the consent of the government. It's not that the government has given you a lease for a particular purpose.
You're bound by the
And
conditions.
you cannot transfer it for a particular period, and thereafter, even if you want to, then the permission is necessary. That would be the ordinary lease. So then produce that lease deed. Let us see that.
Yes.
Let us. After arguing for some time,
And
Mr.
right to resume and
Mr. Jena seeks some time to produce the lease deed, which was issued in favor of the petitioners. Petitioner.
I can produce any one lease deed.
All right. Put up this matter on such and such date. Yes, next. Ajay, Paramedic Yasudha. When date will be, we'll see.
Item 22.
My lord, the present petition is filed that ISCPD paid to the PEP teacher of added educational institution. Do the government allow the same to all the employees of added educational institution? So, the said OA may be withdrawn. OA number 725 2018. Similar
No,
government
which
part-
order you are challenging?
My lord?
Which order you are challenging of the?
Similar
What
judgment
is your
part-
prayer in this? Opposite party number 4, registered Odisha Administrative Tribunal, so and so to transmit the case record of. So this has already been transmitted. What do you further want?
OA withdrawn କରିବା ପାଇଁ
Who wait?
725 2018.
725 ଟା ଗୋଟେ number ହେଇଯାଇଥିବ ନା ବର୍ତ୍ତମାନ ଏଠି ଆସିଲା ପରେ. All the cases which were there before the Odisha Administrative Tribunal that has already been brought to this court and a number has been assigned. So what is the number of that case? As a number say case ro number ପାଇକିନି ସେଇ particular case ରେ ଆପଣଙ୍କୁ ଗୋଟେ memo ଦେବାକୁ ପଡିବ by interim application ଦେବାକୁ ପଡିବ if you want to withdraw the case. Are you not aware about the number of that case?
ନା
Register to ବୁଝନ୍ତୁ.
ନାଇଁ
Almost identical number has been given.
C ଟା ଲେଖା ହେଇକି ଆସୁଛି
ଗୋଟେ C ନା କଣ ଗୋଟେ add ହେଇଛି WPC ରହୁଛି
ଆଜ୍ଞା
ତାପରେ ସେଇ number ରହୁଛି ସେଇ ଯୋଉ 725 ହେଇକିନି
WPC OAC
WPC bracket ରହୁଛି OA then ଏଇ ଯୋଉ 725 ଯାହା number ଥିଲା ସେଇଆ number ରହୁଛି ତ ଏଥିରେ ଆଉ ଗୋଟେ ଆପଣ ଗୋଟେ ରିଟ୍ ଫାଇଲ କରିକିନି କଣ ସେ ପିଟିସନ ଟା ୱିଥଡ୍ର କରିବେ ବୁଝିପାରୁଛ ନା ନାଇଁ if that there is already a case which has already been transferred to this court and it is pending here, you are just to file a memo of withdrawal in that writ petition. Okay? To ascertain. So we are. In this writ petition, dictate time like day after petition, a prayer has been made. For a direction to the opposite party number 4 registered Odisha Administrative Tribunal, Bhubaneswar, Bench Bhubaneswar, to transmit way number 725 of 2018 to this court and also to withdraw the said case. The way number 725 of 2018 has already been transferred.
Records of
Records of way number so and so has already been transferred to this court. Therefore, it has been renumbered. Therefore, the registry shall place the said way day after tomorrow, that is on 8th of May 2015 with this original application, with this writ petition.
You come with the memo on that day and give the memo so that both the things
both the cases will be disposed.
Day after tomorrow, huh?
The next one is same prayer. Next one is also same.
Come with 2 memos.
Page 5, 2025.
Item 24.
Non-disbursement of Sunday hours will also get a similar order. I have annexed of 2 months.
MGC कौन फाइल है सेटा तो हमें पास करलु सेटा सेतबेले ordinarily it is registered as LAR. So एटी MGC कौन लिखा है
MGC भी होउला से
MGC होची
एत जारे LAR होची केतळे जारे MGC होची MGC रे भी ऑर्डर होची
हाँ नहीं पच्चर we just wanted there is no dispute that it was passed under section 18 of the so but this judgment was passed on 15/12/2013 and there was a direction to pay the compensation amount like this. So have you not availed the remedy of filing an execution for this or decree? It is now a decree or this MGC.
Yes, ma'am.
So you have not filed any application for execution.
There was communication gap between the advocate and the
2013.
And in similar cases, your lordship has passed I have supplied the order. Annex 2, your lordship has passed a similar.
Because this order was disposed of. I do not know whether that has been paid or not, huh?
Well, and it's true that order was disposed of 1918.
No, 2018.
You are alone, you are entitled or anybody else?
Yes, my lord, I am here. Satyendranath Sahar is present.
The same person.
Same person.
In terms of that order, you take instruction. This in that order, what we have stated that whether dispose of the writ petition to sanction the amount at an early stage. So we are asking for you to obtain instruction whether any amount has been sanctioned for disbursement to the petitioner of this writ petition in terms of the order dated one. So that instruction you get, right? This writ petition has been filed by the, and this matter will also take in that local dialogue, right? The petitioner Satyendranath Praharaj has filed this writ petition for a direction to sanction and disburse the compensation amount pursuant to the order dated 10/12/2013 of the Land and Civil Justice Senior Division Dharamgarh in MGC number 53 of 2004 within a stipulated period. The Learning Council for the petitioner submits that in similar case, which was filed by where the petitioners approves this court in WPC number 18958 of 2024. Order was passed on 28/2024 under Annexure 2, directing the opposite party number 1, State of Orissa, to sanction the amount at an early stage, and thereafter the Special Land Acquisition Officer Upper Indravati Irrigation Project Kusum Khunti in the district of Kalahandi shall take expeditious step for disbursement of the compensation amount, if there is no other legal impediment. Since the judgment in MGC number 53 of 2004 was passed way back in 2013, let the Land Council for the state obtain instruction as to whether the sanction of the amount has already been made for making payment to the petitioner. And this matter will be taken up in the Lok Adalat, which is scheduled to be held on 10th May 2025. So just pass the instruction so that they will sanction and will dispose of, because the number of cases in the disposal also, and they will get immediate relief.
Thousands of cases are there.
Huh?
Thousands of cases.
So you see that this type of cases, and I think your Advocate General was making a statement in New Delhi that we are taking the steps for in this type of cases for early disposal. So 2013 cases, and we are in 12 years the petitioners is waiting, and you are not, neither you are challenging that order, nor you are sanctioning the amount to be paid to the petitioner. So he says that number of cases are there. So if
We
similar,
should identify and all these matters can be listed in the Lok Adalat.
it can be disposed of.
It is the reference amount, the reference orders, reference judgments. It has attained finality. You have to pay it today or tomorrow. Why are you keeping it pending? Identify those matters and we can list it.
Have you got any other cases of similar?
In lower court matters, not in high court.
Lower court.
No repetition.
Lower court, but final order must have been passed.
Every day it is coming.
Yes, yes, yes.
This type of
I
cases.
have already, I have 20 cases. 30 cases I have filed.
In the High Court?
Yes, ma'am.
But please give the.
It was disposed of.
No, pending cases.
Pending cases, যদি ଅଛି କିଛି ଦିଅନ୍ତୁ ଆମେ
Pending na.
ହଁ, this all right. Yes, next.
May I remember one free copy maybe so that we can follow.
Give a free copy of this one. So, as I go to ଲେଖି ଦିଅନ୍ତୁ, the registry shall find out similar cases if pending before this court and list it in the Lok Adalat, upcoming Lok Adalat.
Item 25.
Free copy of the order.
May I please your lordship?
I don't.
Lordship, can you produce the last order, that is 25th March 2025?
Yes, sir. Yes,
Hearing was fixed.
There was a direction, disposed of the directions to the collector Sambalpur.
Date was fixed on 9/2025.
Thereafter, they come up with a IF for extension of time. That annex 2 I have annexed. Another time will be.
No patch ko achi.
no point.
Date ଅଛି. I pay related after action. In the meantime, you can comply that order.
The Land Council for the state has produced the written instruction received from Collector Sambalpur, which would indicate that the final hearing for disposal of the representation has been fixed to 9/5/2025, and notice has been issued to Superintending Engineer R&B Division Number 1 Sambalpur. See written instruction dated so is taken on record. Put up this matter after ensuing summer vacation date the Land Council for the state shall apprise this court about the compliance of the order. Dated so on. Yes.
Item 26.
First time as China, Naguras.
Notice, but yeah, he has not submitted any.
Matter and submit that he has filed and transfer for modification clarification. So
Modification, your lordship will find is not permissible at this stage.
IA number transfer,
SLP dismissed.
modification form. What is your?
SLP dismissed.
One first of all, he coming.
The SLP against the main order is dismissed. Thereafter, you move an application for modification. In the pretext of pendency of modification application, you will not comply. What is this?
Yes. The order which has been passed by this court, if it has been confirmed by the Honorable Supreme Court, and What is the question of modifying that order by way of filing a IA? If it's just to be implemented,
You also directed another contempt to be listed, it has not come. Because that is also held up and the contempt was dropped because of the SLP was pending. That order is 10/9/13, that the annexure 2 we have filed another contempt. That has not come, you also directed last October.
to which, I mean, it is,
How to kind contempt?
नहीं था अदर किसी डायरेक्शन नहीं नथो खाली अदर थिला डब्ल्यूपीसी सहित आसे उसे तो आसी आ गोटे कंटेम्प्ट सहित आसीबो बोली किसी ऑर्डर नहीं नथा
अच्छा what to continue? No, let me.
all right, we are passing it over, but ask Mr. Katkia to come soon. Yes, next.
Item 27.
Yes, Mr. Mishra, what correction you want?
Wrongly, the lead person when the order sheet type there, 11,619 I have reflected in para number 2 and the OGLS case number 5 of
On taboo, I think correctional of the order dated one. Graciously please to correct the लिखिए कौन आप किसी बोल
number 11,619 type means.
Code typing.
Who type?
Order.
No, correction नहीं है.
Correction ही
triple 199. Triple 199.
Triple 199 तो correction ही यही.
तापरे आगे पारा 2 3 6 रे OGLS केस नंबर 5 और 24 सेटा 21 है.
अच्छा. It about 20, just a minute. Para about 24.
21 and 24 है.
Code अपन पाइबे. नहीं ना annexure देखाम सेटा 24 बेली. OGLS revision number.
The JRS copy of the OGLS petition.
अरे annexure करना है दिखे तो.
नहीं अभी करना है.
अपन averment रे जनु जान लिखती हो से या लिखाई थी.
हाँ सही तो.
Oh, then अपन करती हूँ क्या?
You have to correct your petition. Our order is correct.
No, sorry, my lord. I have also not reflect the OGLS number.
अरे OGLS number अपन averment थी हमें कौन कूड़ जाएंगे नहीं आसिलु मुरुडु. OGLS number अपन देना थी petition ने.
नहीं petition देना थी लड़से मांगले पर JRS copy करने
दे. How we came to know that the petitioner so and so has filed this writ petition challenging the order dated so and so passed by the collector in OGLS revision number so and so. That is your prayer.
They separated a copy at the time of disposal. My lordship is act to the whether any document.
हाँ, से copy ले कौन लिखा है इधर?
JRS copy 5 और 24.
अच्छी copy.
How would a copy अच्छी? रेयर क्वेश्चन ने सेगुडा का नंबर टा लिखि नथिले
ना
आमे पछियालु से केस नंबर केते सेति बेले उडा कोन बढाई दे
फाइल सबमिट.
हां सेटा देउंतु को जदी से नंबर टा भूल ही जाई जी 21 जगह रे 24 जगह रे 21 लिखा ही जी दिउंतु से तार कॉपी. आपण जेते गोटे ऑर्डर टा चैलेंज करथिबे 21/2/2025 रो ऑर्डर टा चैलेंज करचंदी एंड यू हैव नॉट एनेक्स्ड दैट इन योर आपण एनेक्स करचंदी पर एनेक्सचर 8 एनेक्सचर 8 रे से नंबर टा नथिला ओके हां तेनु सेति पई हमें पछियालु जे तार नंबर टा केते ओके एनेक्सचर 8 डज नॉट मेंशन दैट OGLS नंबर तो आपण देइथिले जेरॉक्स तोटे देइथिले तो देखांतु से जेरॉक्स रे बदन आउ कार गोटे जदी सेटा ही थिवो ताले से डायरेक्शन दा असुविधा हियो ना.
ना सर आवश्यक हमर सर्टिफिकेट कॉपी
ये सर रिकॉर्ड आसी
सर्टिफिकेट कॉपी हम
दियन OGLS रिवीजन नंबर 5 of 24. अच्छा ई उडा से न बढ़ाइतिले
हां जेरॉक्स का बढ़ितले
ए से जेरॉक्स टा रिकॉर्ड होतिबो तो कारण एटा बही कॉपी थिला ना. हां नहीं Last procedure, yeah, it article back from back. এটা ଅଛି 5/24 এটা দিয়ে দিও না ଅଛି লেখুন the this is an IA number so this is an application for correction of the order dated 1/5/2025. The Land and Council for the petitioner submits that inadvertently in the parts of paragraph of the order the OGLS revision number has been mentioned as 5/2021 in place of OGLS revision number 5/2024. And the same may be corrected. The Land and Council for the state has no objection. Accordingly, in so paragraph where OGLS number has been mentioned as so, the same shall be read as 05/2024. Rest part of the order of dated so remains unaltered. IA is disposed of. Yes.
ସେଇଦିନ 15 ଦିନ ଆଜିଠୁ 15 ଦିନ ଗଲା
Acha, okay. Our time fix of it. If such an application, acha. Rest part of the order to katti diyandu. Since in the operative part of the order, the application was directed to be filed within 15 days from the passing of the order, and we are modifying the order today. The 15 days shall be counted from today. The rest part of the order. Yes.
Mr. Kotke has come.
Yes, Mr. Kotke. Call that item.
Item 26.
Yes.
Yes, I have filed one IA.
Yes, sir. The order was confirmed by the Honorable Supreme Court. Thereafter, what is the IA?
That is also can come to page 2 of the order. Impugn order. That is order dated
You can accept.
15/5/2029. Sorry, 19. 15/5/2019.
Where is that?
Annexure 6.
Your also is only the contempt or repetition?
Annexure 6. Contempt.
Contempt petition, Annexure 6. Yes.
Which paragraph?
No, sir.
15/5/2019. Yes.
Yes, that is just page 35.
Yes, page 35. Okay.
Yes. There plus we are of the view plus on the first line. The right corner. We are of the view that till the Raurkela Development Authority completes the part of the project as undertaken, that they will complete the basement. This word basement is create the enter confusion and ground floor. Within a period of 6 months, excluding the rainy season, and give allotment to the shopkeepers who have occupied person. Because I don't have any objection anywhere. Then again, that has been used. Just a few lines under that particular part. Raurkela Development Authority that they will pay the license fee within a period of 4 weeks from the date of vacation of the land, as well as they will also give an undertaking that they will not create any hindrance for construction of the basement and ground floor in the meantime. Actually, it should have been first floor because construction is required to first floor and ground floor. There is no requirement of basement because one basement, this word basement has come up by the way. Well, this is an obiter. My humble submission for Lordship is. By the way, it has been reflected, not instead of first floor, it has been written as basement. So, if basement is being constructed, that means I have to incur the around 14 crores. That is not required. For ground floor and first floor, basement is absolutely not required. There is only foundation is required. A strong foundation is required. That particularly I want to modify that basement what should be replaced by first
There is
floor.
the Supreme Court order.
Supreme Court, the supponents have challenged this order before the Honorable Apex Court. The Honorable Apex Court, this order has been upheld. Upheld. Now what the petition is saying that you make the basement. He's insisting for basement. We are ready to do the ground floor and first floor, but he is insisting for basement. So that is the reason why basement, that what basement should be clarified as first floor.
Basement can be first floor only.
No, what he said that is not correct.
No, if any,
Please.
neither in the agreement, nor in the petition, nor in the counter, nowhere the basement what has been used.
You have filed the counter in the Apex Court. You have never taken such ground. Rather, this has been acknowledged by this Honorable Court. Your Lordship kindly
Where is
see.
the agreement? So,
Your Lordship kindly see.
where from this basement has come?
No, that
I'll
clarify. I'll clarify. Lordship kindly see the order dated 10/9/13 of this Honorable Court. That is page 13. Yes. Page 13 and page 15, your Lordship will get it.
What is the page?
My Lord, page 16, Lordship.
Hmm.
The Lordship kindly see, this was pursuant to the direction of this Honorable Court that their design, planning, everything was given and it was recognized. Then your Lordship on the heading that benefits on implementation of new plan. Then your Lordship will find E. Modern building with the
Ample parking space.
as per the present RDA regulation
In the basement.
making the building self-sufficient for parking such. Thus,
Yes.
thus it is
Decreasing
Decreasing
and congestion.
Basement is there.
So
Parking basement.
then your Lordship kindly see, this has been taken note and further acknowledged that Lordship kindly see page 34. That means to which
So this is the report of the opposite party which has been quoted there.
Yes.
That is Annexure 8.
Mine.
And obviously the opposite party is the Routledge. So
Then this has been also taken note in page 34. Page 34.
34.
That means which judgment is bringing to Lordship notice and that was challenged in the Apex Court and was ultimately dismissed. Lordship kindly see page 34. Last paragraph. Considering the above, after going through the earlier records and orders passed by this court in WPC number so-and-so, 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 then your Lordship kindly see so-and-so, so-and-so. Last, but the last third line, WPC number 9131 of 13 disposed of on 10/9/30. That's the
one which we have read.
Yes. So everything has been recognized. So how can you take a U-turn here? Their Lordships have applied the mind and passed the order.
But in a contempt jurisdiction, why should you go into all this? As simple as
yes.
There is an order, it has to be
So
complied.
this is the way how to delay the process.
WPC number 11223 of 2025. IN number so and so is an application for modification of the clarification of the order dated 15/5/2019. It appears that the order dated 15/5/2019 was challenged before the Honorable Supreme Court by Prakash Kumar Parida and others in SLP number 14180 of 2019. And the Honorable Supreme Court was not inclined to interfere with the impugned judgment and order, and accordingly the special petition was dismissed on 21/2025. In such a scenario, we are not inclined to entertain this interim application for modification. Accordingly, the IA stands dismissed. Yes, now the question of contempt arises. So,
Yes, one moment, may I humbly submit one also.
Yes, who is the opposite party? Avina Asutosh Kulkarni. Has he filed any?
One preliminary affidavit plus.
When will comply the order? Query that affidavit.
I'm filing preliminary affidavit. take it on record. I have to, because the process is on.
Ashutosh Kulkarni.
That the secretary has filed this affidavit. The open note 2.
Secretary. The direction was issued to whom?
To RTA.
To the active.
The RTA.
It means they both are the parties.
ମାନେ vice chairman और secretary ଜଣ party କରୁଛନ୍ତି.
Where have you stated that petitioner is not cooperating with the opposite party in the process of carrying out the responsive on the allegation? Where have you stated that the process is on for complying the order?
Yes, boss.
This is nothing. We are just
Again, you are
ignoring
bringing
this.
that story basement.
No, that is last part.
Preliminary affidavit has been filed on behalf of the opposite party. After going through the same, we are not inclined to accept this affidavit. The
You'll also can say Annexer A1 and B1 series.
Parties number 2, 1 and 2. Sir,
Annexer A1, B1 series.
On 8th of May 2025 to virtual mode at 10:30.
For a moment, you'll also kindly appreciate
That's
it.
all. Yes, sir.
For
Supplemental list, item number 1.
Madam. So in your name, prisoner's petition has come. Oh, the wakalatnama is available, no? Yes, sir. You have to fill it out. Have you got the judgment copy and अच्छा ऐसा fill up कर दियंतु हमें आपन को provide कर दोछु जो prisoners petition टा आपन नार आस्तिला सेटा को दे दोछु plus judgment copy टा भी दे दोछु है ना and there is a bail application pending so तार copy मध्य देइछु दोछु so you go through it and it will be taken up next week. You move the bail application.
After.
That's what I'm saying. लिखन दो मेरे को। जल्दी लिखो।
Peruse the prisoner's petition. No, two prisoners' petition have been received. One is at flag A for engagement of Advocate R. Biswal in place of Advocate S.K. Gupta, and another prisoner is at prisoner's petition is at flag M for engagement of Advocate Devaki Marandi in state of Advocate S.K. Gupta. Since the prisoner's petition at flag M is the latest one, which is dated 29/11/2023, we accept the prayer made in this prisoner's petition and engage Devaki Marandi as the advocate for appellant number 2. 2 na say? Petition number 1. Appellant number 1. Rehabilitation now. Advocate Devaki Marandi is present in court, filled up the Wakalatnama of appellant number 1 Bidesi Nayak and filed the same, which is accepted. Let a copy of the prisoner's petition at flag M, the impugned judgment. So also the interim application filed by the appellant Bidesi Nayak, while IN number 72 of 2021 be handed over to her. Stop. She can also collect the deposition copies of all the witnesses, soft copy of the deposition copies of all the witnesses in her pen drive. Put up this matter. You want it after vacation? Put up this matter after in the week commencing from 23rd June 2025. In the meantime, the Learned Counsel for the state shall produce the custody certificate of the petitioner. Appellant number 1. आपण पारे पेन ड्राइव अबिका अच्छी तो पेन ड्राइव टे नहीं जानतु से डिपोजिशन कॉपी गुड़ाक आ बाकी गुड़ाक कोर्ट आवर पर से आपन को सप्लाई कर दबो जो प्रिजनर्स पिटिशन रे आस्तला आपन को रिक्वेस्ट कराइतला ताकू भी देबे जजमेंट कॉपी दे देबे आ बाकी से गुड़ाक आपन को जेरॉक्स दे देबे बाकी डिपोजिशन कॉपी गुड़ाक आपन को पेन ड्राइव आज आपन जदी नथि कार फ्रेंड रो पेन ड्राइव आनी नहीं जान collect for them so that it would be easier for you to move the application for bail. Yes, next.
Item 2.
Premature release.
Premature release. So, part B. Thank you. Period the release report at flag D, which indicates that the petitioner, where the appellant Balram Sira, have been released prematurely on 25/5/2023. Accordingly, the CRLA is disposed of if the appellant intends to challenge this one, so he can file an interim application. Yes, next.
Item 3.
The last position of the guidance for the conduct of the appellant when it was in 18 days.
You are granted interim bail for a period of
3 months, again 15 days.
2 weeks ଆପଣ ଯାଇଥିଲେ ଲାଟେଷ୍ଟ 19/2/2025 ରେ ତା ପୂର୍ବରୁ ଆପଣ
3 months.
6/5/24 ରେ ଯାଇଥିଲେ 3 months, right? Part the learned counsel for the petitioner and counsel for the state in pursuance of the order dated 23/4/2025. The learned counsel for the state has produced written instruction received from IIC R. Udayagiri Police Station dated 29/4/2025, which indicates as follows, quote for TPN. The learned counsel for the petitioner submits that the petitioner has been granted interim bail twice. First time in IA number 175 of 2023 as per order dated 6/5/2024 for a period of 3 months, and again in IA number 37 of 2025 as per order dated 19/2/2025 for a period of 2 weeks. And since there is no chance of early hearing of the
in this case,
appeal,
eyewitness, it was 16 is
merit
the-
ଆମେ ଦଉନୁ ତ therefore the merit already reject ହେଇଯାଇଛି.
No, man, reject any. This is our
Mr. Counsel, have you gone through the order dated 6/5/2024? Everything has been discussed, and thereafter we have held that we are not inclined and we are granting you bail for 3 months. Lekon, since there is no report that the petitioner has flouted the terms and condition of the interim bail order, we are inclined to release him on interim bail for a period of 3 months. Lucky there were date fixed for the IA is disposed of. You file the surrender certificate, huh?
Item 4.
Please. One idea for interim bail on the ground of marriage of
What in this condonation of delay? Is there any delay, stamp reporter? So, you push 90 days for them. It is 90 days. So delay has not been condoned, has yet? How so many orders have been passed?
The bail application was also turned down, my lords.
No.
In that interview, it has not been turned down. 98.
The stamp reporter has clearly mentioned that the date of judgment is 21/1/2019. And you presented this criminal appeal on 19/6/2019. So the limitation period is 60 days. And therefore there is delay of 90 days.
But when IA has been filed at the time of filing of the appeal, my lords.
No, that has not been condoned. So question that you should have pointed it out. IN number 998 of 2019. There is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 90 days in filing the criminal appeal. Stop. After hearing the learned counsel for the respective parties, and since the petitioner has been sentenced to undergo imprisonment for life, we are inclined to condone the delay in filing the appeal, criminal appeal. Accordingly, delay is condoned, IA is disposed of. Hard admit. Stop. Yes, now you. Which IA?
For interval, I have obtained instruction.
Which one?
IA number 1261 of 2020.
1261. On ground relation the
Marriage of the only son of the petitioner, appellant.
Kibe?
On 8/5/2020.
Marriage card. कौन आसिला report? Is only some lead to alias going to Manoj Manson is going to try Manson. अच्छा reception केबे अछि 11 तारीख दिन
11
दिन दो the IN number so and so, there is an application for interim bail on the ground of marriage of the only son of the petitioner. Marriage invitation card has been annexed to the interim application. Land counsel for the state has also produced the written instruction received from IAC Tigriya police station, which indicates that the only son of the petitioner is going to tie the nuptial knot on 8/5/2025. The report is taken on record. Considering the averments taken in the interim application, the instruction obtained from Swansea, we are inclined to release the petitioner on bail for 4 weeks. Yes, IA is disposed of after date fix of further surrender certificate.
Limited prayer notes can be in course of the day.
Good.
Item 5.
Police from the date of release. Yes, Mr. Tripathi. He was not present last date also, I think. Why Mr. Tripathi's name is there? 63 of 2019. Miss Satabdi Samantray.
No, it's experience.
Oh, sure. On that ground, it's only 7 years of practice. We engage Mr. So-and-so. Except the name of.
I did.
Huh?
The intimate.
Okay.
इस शताब्दी ना कभी शो करेगा
कस्टडी सर्टिफिकेट असला लेटर टा पण असला Rajesh Tripathi has been appointed as convicted has not been released on interim bail during the tenure in jail custody as reported.
12 वर्ष 5 मास.
But he is not filing any application for bail also. This was, I do not know whether this intimation has been given to the Mr. Tripathi. Otherwise, he should have collected the judgment and this the trial court record जो deposition copy वैसे paper book भी है ये ज्यादा है. Oh, you have not got the number of Mr. Tripathi. So just contact him. What is there? He can join also. We are passing it over. Just give a call to him. Huh?
12 years, 5 months he has already undergone. At least he is entitled for free. Just check it.
Pass over. Next matter.
Item 6.
Interim bill for second daughter marriage on tomorrow. 7
Puja?
7/5/2025 से बाहर.
You are moving the first one, 625.
624 marriage. IA number 1256.
Verified?
Yes, sir.
सात पांच मैंने निकाल दी. Look on the IN number one. So this is an application for interim bail on the ground of marriage of the second daughter of the petitioner, which is going to be solemnized on 7/5/2025. Marriage invitation card has been annexed to the interim application. As per order dated 5/5/2025, the line counsel for the state has received the instruction from IIC Marsabhai Police Station, which indicates that the marriage of the second daughter is to be held on 7/5/2025. The report is taken on record, considering the submission made by the land council for the respective parties. The government taken in the interim application, the report received by the land council for the state. We are inclined to release the petitioner on interim bail for a period of 4 weeks. Now, date for papers will file the surrender certificate. And this is due for the
in course of the.
Yes, sir.
Well, item 5, Mr. Tripathi is now outside Cutters at the airport. Well, next week.
All right. Item 5 and it is stated at the bar that Mr. Rajesh Tripathi, London Amicus Curie, is out of station and the matter may be taken out after ensuing summer vacation. This matter after summer vacation.
Item 7.
Well, I will pray for absent.
Mr. Tripathi, Land Council, appearing for the appellant 6 adjournment. IN number 157 of 2024. This is an application for bill 6 for an adjournment after summer vacation. Yes.
Item. Many adjournment.
Yes, Mrs. Modi.
I have an interim application for extension of time, but with due respect, the matter could not be listed. So today was the last day to surrender, and he had surrendered, as per to my information, he had surrendered today in the morning. So this IA application becomes infructuous.
The Land Council for the appellant submits that the appellant, after availing the interim bail period, has already surrendered, and therefore the IA has become infructuous. In view of such submission, IA 114 of 2025 is disposed of as infructuous. Yeah.
Item 9.
Yes,
The appellant is behind bars through 38/2021.
Mm-hmm.
Appellant is behind bars since 38/2021.
ତିରିଶ 8/2021।
Convicted for an offense under section 302 IPC number.
What are the materials?
Those eyewitnesses are there.
Who are the eyewitnesses?
So PW 2 and PW 10 is the eyewitnesses.
PW2 and PW10. Who is the doctor?
PW 9.
PM doctor.
No.
PW9.
No.
So what is the weapon of offense? The free.
No.
एड़ा को तो पूरा एमुडो सेमुडो जाए खाली चॉप डोंट बोड़ा माने केतेटा दी मारी केंदा
Altogether 9 injuries.
PW9's deposition.
Altogether 9 body injuries.
asi 9 रो मु देखछि तो 9 रो
Fingers were also severed.
चॉप डोंट आउ किछि
तीनटा अंगुठी काट देछंती बॉडी सारा इंजरी
4 number of chopped fingers नहीं चारटा chopped finger है
Right.
Roman 3 रे
4 number of severed fingers were as per the
right hand रो chopped wound ରହିଛି thumb index middle and ring finger ଯାଇଛି ତା ଛଡା neck ର injury ଟା ହଉଛି 17 cm 6 cm bone deep ତାପରେ next ଟା ହଉଛି right ear left ear ମାନେ ଛାଡି ନାହାନ୍ତି ଆଉ କହୁନାହାନ୍ତି
PW2 is directly.
PW2 has stated that you assaulted by means of a cautery.
PW2
got out one cautery from the soil and tried to assault them.
recovered under section 27.
I mean subset many things.
And your period of detention even has not crossed 4 years. So we are not in that. Look, in view of the eyewitnesses account of PW2 and PW10, coupled with the medical evidence adduced by PW9, who has noticed a number of chop wounds on different parts of the body, including neck, and further opined that death was due to shock and hemorrhage. After hearing the learned counsel for the state, we are not inclined to release the petitioner on bail rejected. Yes, next.
He contempt was all throughout. He faced the trial as a UPP or interim relief. If
No, the 3 years. Next, item number 10.
Item 10.
Deposition copy may be given.
Deposition copy, let the learned counsel for the appellant supplied the deposition copy of the witnesses. The learned counsel for the state in court today to take some time to go through the same put of this matter after ensuing some vacation. Yes.
Item 11.
Year number so and so. As a receive question, the deposition copy.
Paper book is there.
Paper book question. On offense कौन हो?
302.
302. Direct evidence na sir, substantial evidence.
Direct evidence. There are 3 eyewitnesses, 9, 14 and 20.
9, 14.
PW18 is the doctor. And the weapon of offenses has been recovered under section 27.
What is the weapon of offense? PW9 though?
Yes, 9, 14 and 20 euros.
Are the accused person so and so
Kati iron rod.
restrained so and so attacked with the Kati iron rod Bhujali, and they caused injuries all over the body, including the head. At that time, some other accused persons whom I do not know pushed me so and so and beat me. Doctor ki hai?
Dr. Miller, 18, CW18.
present appellant is holding a axe.
Chopped wound, stab wound, lacerated wound. Cause of death was due to severe hemorrhage and shock due to multiple injuries caused by sharp and heavy weapon. ये कौन धरतिला?
Axe धरतिला.
Axe धरतिला.
PW 14 paragraph number 2 may I plus. May I read?
That was also recovered at his instance.
Not as his instead of the co-accused Co-accused one Siddheswar, who is now facing trial since he was apprehended late, so trial was picked
How
up.
many years you are in custody?
My lord, 4 years, 10.
4 years से कौन होगा?
My lord, specifically, assault project case देखिए direct omnibus allegation.
Omnibus allegation. ଆପଣ ଧରିଥିଲେ କଟୁରୀରେ ସବୁ ତକ ବ୍ଲୋ ତ ଅଛି sharp cutting weapon ରେ main ବ୍ଲୋ ଯେତିକି ରହୁଛି.
May I place PW 14 for him?
PW 14 କଣ?
PW 14 paragraph number 2. About 3 years back, one day at early morning, while Digambar Sahu is the deceased, was proceeding towards the agricultural land. These two accused persons, these two are this present appellant and the co-accused Manoj, who is the appellant in the connected appeal. Accused person along with Sana Dehurit Siddheswar Bhai attacked him being armed with X. Accused Babulu dealt axe close to him. He is the Babulu is the present
appellant, this petitioner, yes.
Thereafter, the accused Sana Dehurit caused injury to his by Kati. Accused Siddheswar Bhai beat him with an iron rod. Accused Manoj beat him with a stick. At that time, others.
Axe recovered?
Axe recovered, yes. And axe recovered at the instance of the Siddheswar Bhai, who was arrested 3 years later. Paragraph 3 of that statement only. May I read? After 3 months of occurrence, police called me and my husband to police station. At that time, accused Siddheswar Bhai was present at the police station. In our presence, he confessed to have committed the murder of Digambar Sahu in association with other accused persons. Further, he told that he has concealed the weapon of offense such as axe, kati and iron rod inside a well adjacent to the spot of occurrence. Then the police took me to the spot and accused Siddheswar Bhai brought out axe, kati and iron rod from that well. But Siddheswar Bhai arrested on 11/9/2020.
So, what is your period of custody, you said?
My lord, 26/6/2020.
26/6/2020. 2020.
My
Eyewitness है क्या?
PW 9, PW 19,
14, PW 9, 14 and
20.
20. And doctor है
18.
18.
PW 18. PW ये कोई चीज जो स्पेसिफिकली थी जो वहाँ आम पता?
PW 14 है.
PW 14.
PW 9 का deposition prior to occurrence, would a tubewell को नहीं कि there was a dispute between the accused and the deceased?
Civil.
Accused
By the present appellant.
But 9 and 20 he has not specifically.
Not specified. No.
Only 14 has.
Only 14.
14 relative of the dismissal.
Or the learning counsel for the petitioner and counsel for the state. The learning counsel for the petitioner submitted that the petitioner is in judicial custody since 26/6/2020. And the eyewitnesses to the occurrence, PWs 9 and 20,
9, 20 and 14
have not stated regarding the weapon of offense held by the petitioner, and their statements are omnibus in nature. It further submits that due to previous civil dispute between the parties, the petitioner has been falsely implicated in the case, and since there is no chance of early hearing, the bail application may be favorably considered. And counsel for the state, on the other hand, that apart from PW 9 and 20, PW 14 is also an eyewitness to the occurrence, and he has stated that the petitioner dealt axe blows to the deceased, Digambar Sahu, and the doctor bracketary PW 18 who conducted post-mortem examination has noticed number of chop wounds on different parts of the body, including the scalp, and opined that the cause of death was due to severe hemorrhage and shock on account of multiple injuries caused by sharp and heavy weapon. Considering the submission made by the learned counsel for the respective parties, the eyewitnesses account of the three witnesses, PWs 9, 14, and 20, coupled with the medical evidence adduced by PW 18, we are not inclined to release the petition on bail stands rejected. Yes, next.
Item 12.
Item 12. Prisoner's petition has come for engagement of Mr. Jafrullah in place of Wakalatnama filed. Prisoner's petition has been received from jail, which is at flag C, regarding engagement of Mr. S.K. Jafrullah as the advocate. Mr. Jafrullah has already filed Wakalatnama, which is accepted. The name of Mr. Shivani Shankar Pradhan shall not be reflected in the cause list henceforth. And paper book you have received. Let a copy.
I filed an interim application for bail. And also for stay.
No. Bail application is already there.
Filed ballot that deposition copy I don't have.
No, you receive the paper book, everything would be there. No? And let a copy of the paper book be supplied to Mr. Jafrullah. Aji nahi janta in course of the day.
Face matter.
Oh, paper book is not ready actually.
Face matter.
Oh, I see. Achha, let the trial court report let the deposition copies of the witnesses examined in the trial court be supplied to the learned counsel for the appellant in his pen drive. And put up this matter after. You want to both summer vacation for consideration of the bail application. Yes. Yes, next.
Item 13.
Yes, leaders. Here, there are three appeals. Because criminal law is active and at the top is concerned this way before also in last occasion on 24/4/25 and also directed to supply copies of the evidence which I have done now. And so far the next criminal appeal is concerned, criminal appeal 50 of 25, there are 8 accused persons. Some little chart is necessary as to who was implicated whom. So therefore I pray that so far as criminal appeal 50 is concerned, but also may call it after vacation.
No, we will hear together, not that piecemeal one. You prepare the chart, we will hear it.
So, yes. So far,
Mr. Harmon Dhar and counsel appearing for the appellants in CRL number 31 of 2025 and CRL number 50 of 2025.
May I be pardoned?
Yes, sir.
No chart is necessary.
Prepare the chart and put up this matter after summer vacation. Also summer vacation.
Criminal appeal
chart is
criminal 31.
I have already appeared for the information.
Mr. Vijay Kumar.
One case has come, other 2 cases have not come.
Other cases not come.
Already filed, my lord. There are 3 cases, my lord. Out of 1 case, my lord, my name is requested.
The Mr. Robert submits that he has filed Wakalatnama in CRL number 31 of 2025, so also in CRL number 430 of 2025. Let the registry place the same on record and the name of Mr. Robert and his associate be reflected in the cause list henceforth. It are passed by order 31 रे ଆଉ 430 ରେ ହେଲା
Custody certificate
the state council produce the custody certificate 23/6/2025
also criminal antecedent.
criminal
Good.
next
You call it next week.
sorry yes next
Item 14.
14 Mr. Chan
Today it is the.
Case, but today it is custody for about 5 years. Absolutely no.
today
Just today I received the copy of the
deposition copy. So you go through it. Mr. Chand has already supplied the deposition copy to the Land and Council for the state in court today to 6 in time to go through the same put up this matter after summer vacation.
Before vacation, 5 years in custody.
Our सप्ताह गुड़ाए case of
Absolutely, कोट्टे भी सही support करना. Only based on this evidence of the doctor, which is also contradicted by the other doctor.
साकी eyewitness अच्छे परा.
किसी कोट्टे भी ना देंगे. If they
केमती conviction केमती है.
like केवल का doctor लगा. That is the strange matter. कोट्टे भी वाके उठाएंगे. Admittedly, the body was found outside the house. It was bolted. The house was bolted from outside. All these and the people 1, 2 are the just neighboring witness. After getting the mobile call, they went.
आपनको स्त्री
again.
आपनको घरे
Again.
गोटे रूम भितरे मरिकिनी पड़ी
रूम भीतर मत नहीं रूम भीतर मतलब वो केस नथला
हैला जे
रूम बाहर
ता धीरे इनसाइड वुंड
इनसाइड वुंड जो तारो रीड गुडा भांगी एक्चुअली कहउचंदी
हमर पर एटी हम देखु जे हम इनसाइड वुंड ऑन दिस वन सो lacerated wounds bruises abrasions as many as 9 injuries are there internal injuries are there so how it's a case of homicidal death as per the
1 minute
come
11 and 12 11 is criminal doctor who has not found any injury
छुट्टी पर yes next
पूरा 5 वर्ष होइलानी
yes next
Item 15.
hearing
Item 15 my
may be director of the procedural that
ଏଇଟା କରିଦିଅନ୍ତୁ custody certificate କରିଦିଅନ୍ତୁ ଆସିବ
Item 15 are already consent given to some other council matter. My name may be deleted.
କିଏ ନେଇଛନ୍ତି consent
Some Raut may not. Saroj Kumar Raut.
ସରୋଜ କୁମାର ରାଉତରାୟ
My lord.
ଦେଖନ୍ତୁ Mr. Robert Land Council submit that since consent has been taken
Consent no prisoner petition I will come.
अच्छा since Mr. Saroj Kumar Rautray who order
What bail order ହେଇଛି ଗୋଟେ order. No. 16 Mr. Mahanti man on behalf of Saroj Kumar Raut.
Since Mr. Saroj Kumar Rautray has been engaged as the advocate for the appellant as per order dated 12/2/2025 his name so also the names of his associate cannot be reflected in the cause list henceforth. In view of such submission, only the name of Mr. Saroj Kumar Rautray be reflected in the cause list. Yes, what gale se Saroj Kumar Rautray.
Bail hela para.
item 14 custody certificate and antecedent also.
अच्छा 14 ने कर देबे खाली से नहीं चलती custody certificate और antecedent भी नहीं yes just किसी खाली एतिकी ऑर्डर करछु बाकी देखियो कि अछंती सु कि अछंती कि अपील सुनानी 16 ने करियो
Item 16 on behalf of Mr. Patnaik after vacation.
फॉर्म पछाउ जे हम कि अछंती हियरिंग करियो ପାଇଁ
Item 25 and 18.
25
Custody for 18 years.
18 years.
eyewitness
It's a multiple murder case. Eyewitness, one eyewitness case entered based on only one eyewitness.
state is ready criminal appeal देखिछंदी
Triple murder, I pray for it.
triple murder
Single witness case.
how like criminal